Senate Bill 58 and Senate Bill 104, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and selected legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform, and the public has access to contemporaneously listen, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting does comply with House rules and RSA 91A. Anyone who has a problem accessing the meeting should call 603-271-3600 or email hcs@ledge.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. Please note that any votes taken during this meeting shall be done by roll call. So I will start the subcommittee meeting by taking a quick roll call attendance. I am Representative Pearson, I am the chair, and I am present in the room. Representative Allegra.
Present in the room.
Representative. Oh Lord, Sonis, I butcher your name every time. It's horrible. I apologize. Representative Schmidt.
I am present in my home office here in Dover, and I am alone.
And do we have Representative Schuett? Yeah. You know.
You have a few extra Dems, though. Yay.
So I will open the subcommittee hearing on Senate Bill 58. And a reminder to those at home, it's an act relative to the administration of occupational regulation by the Office of Professional Licensure and Certification. This is a bill that went through the Senate last term and died in the omnibus. The main gist of this is best word I'm looking for here is it's a standardization of practices within OPLC across the boards. That's the reason why it's so thick, because it makes consistent changes to the various boards. So I'm open to discussion on this. Certainly, if anybody has any concerns or objections. The titles. Peter, I went through the titles here, and just to highlight the titles when they changed from board to board took me 20 minutes. So, you know, this was quite a long read. But if anybody has any particular points they want to make, certainly raise their hand.
Can I ask some
Sure.
a couple of general questions?
Sure, Representative Libro.
I'm looking on. Thank you. I'm looking on page 1 to start with.
Okay.
And you know, the bold-faced italic thing, the changes. For instance, the office may contract for services of investigators, hearing officers, legal, so on and so forth. A little further down around line 19. I guess my general question is clearly these things were put in because these provisions weren't the case before. They all seem like rational changes to me. Can you give me a little bit of background so I can understand
Sure.
why these things already weren't the case?
It's my understanding that at one time the various boards had specific investigators to their boards. And what has happened, of course, is that has bloated things, where now this, the way I read this, it gives them the ability to not have to have standing investigators, and they can bring in folks rather than, you're talking 50, 53, almost 50, soon to be 54 boards here. That's a tremendous amount of people if every single board had its own investigator. Hi, Representative Schuett.
Hello, if I may, Mr. Chair. Having been on this committee for many years and been concerned with what happens in OPLC via JALCAR also, many of these boards were originally autonomous little agencies around Concord. It was felt that if they were put under one main branch, that particularly clerical work could be shared. A lot of them had clerical help that served part-time. And so it was felt that as an economy measure, they could house them in one place and have, for example, one secretary, we'll call that person, take care of the paperwork for more than one board. So I hope that helps understanding of how OPLC came together with all these varying parts.
Thank you.
And Mr. Chairman, Lindsay Courtney, the executive director, has joined us in the attendees. I suspect she'd be
Yes,
happy to answer questions if you like.
absolutely. Yeah, we can bring Ms. Courtney in. Ms. Courtney.
Mr. Chair, be sure you're speaking into your microphone. We could
Yes.
barely hear
I
you.
apologize. I clicked it off. Yes, Ms. Courtney, if you would like to weigh in here on Senate Bill 58.
Good morning, Mr. Chair, members of the subcommittee. Thanks for the opportunity to speak and appear before you today. Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. Yeah, so this bill is really just a cleanup bill from our perspective. There are a number of things when the office was created. First of all, I disagree that there is a consensus about what we're supposed to be doing here versus the boards, but in any event, it remains clear that we haven't been able to efficiently operate the office by virtue of the fact that there remain conflicting provisions between OPLC and the various practice acts. So there are a number of things that we attempted to clean up. I think it was last year in Senate Bill 576, and unfortunately didn't go through because of COVID. So we essentially split up those two bills. This is a policy bill really just designed to clean up and further clarify and permit the office to carry out the efficient activities that it's required to do. The first being really establishing a retention policy. This is a problem that was really exacerbated by the physical relocation of the office, which wasn't done at the request of the office. I might add, it was quite expedited, and we had to move in a matter of about 30 to 45 days. And we essentially have paper everywhere. And part of the problem is that some boards have retention schedules that are approved by a Secretary of State that conflict with each other for the same types of records, like disciplinary versus licensing. And we don't presently have the authority to adopt or promulgate a policy across the agency. From our perspective, a licensing file should be treated the same regardless of what profession it is, and the same is true for a disciplinary file. So that was kind of the gist of a portion of this bill. Are there specific questions, or do you want me to just kind of walk? I mean, are there specific questions? I already testified, so I don't want to go into great detail. But essentially, this is just intended to be a cleanup measure and not provide substantive changes.
I think it would be more than appropriate to, if folks have questions for you, they're directed at you to certainly do that. I mean, that's the purpose of the subcommittee. So,
right.
Representative Schmidt.
Thank you, Mr. Chairman. Well, let me begin by saying that I agree with Lindsay that this is essentially a cleanup and trying to pull together the operations of OPLC in a more standardized form. I think one of the aspects is that the investigative capability of the boards was kind of hindered to some degree, certainly by the fact that the boards were engaging frequently one of their own members to do investigations. Well, that person might be very expert with regard to the that particular profession's particularities and peculiarities and so forth, that the person might not be particularly skilled at investigative or potentially prosecutorial aspects. And so having somebody, we've heard from Mr. Porter several times going into today's meeting with regard to his function. You can see he's, not only a trained lawyer, but also a competent administrator. So he brings that whole aspect in a way that many of the boards would not have had personnel capable of doing that, however much they may have understood their own professions. So, and OPLC was intended from the very beginning to be a support structure and standardization and so forth. Everything that Lindsay just alluded to is correct. So I think that having her give her a bird's eye view is helpful to people who don't have the background that some of us who've been on the committee for a long time bring to the table. So I'm happy to have her talk, but if anybody has specific questions, let's have Adam. Thank you.
Representative Schuett.
Thank you, Mr. Chair. Good morning, Lindsay, Ms. Courtney, sorry. I'm curious if I assume you have spoken with members of the various boards, particularly with reference to retention of records. And I'm wondering if, due to the differing areas of expertise for the various professions, if there could perhaps be different needs for length of retention depending on the board, and how much consideration was given to those aspects.
Yeah, thank you, Representative. I don't have an opinion on what the retention schedules should look like based on the file type. I think it's important from an efficiency standpoint that we have one or two different types of retention schedules versus what we have now, which is basically 54. And we just can't administratively support that. I have spoken to a number of the boards, and the boards are not, opposed to having a one retention schedule. I think they feel the same pain that we have, although they're not living in, they're not in the office, so they're not, covered with files. The boards do want to be part of the process in terms of determining what's appropriate, and I absolutely support that. I'm not sure that the subject matter really should dictate what, in terms of there should be board specific retention schedules. A licensing file is a licensing file, regardless of what profession you are a member of. A physician licensing file will certainly carry different information versus like a cosmetology licensing file. But when we think about the purpose of a board, which is to protect the public, that whole purpose has to weigh into the factors in consideration of how long do we keep this file. And I don't really think that that's suggestive, or I don't think that the subject matter of the profession really should dictate that. I think we can easily come up with some sort of agreement where a licensing file is kept for a certain period of time, a disciplinary file is kept for a certain period of time, maybe an inspection file is kept for a certain period of time, regardless of the profession. But obviously, I welcome the board's thoughts on that, certainly as we move forward.
Thank you. And do you have a plan to, meet with the various board members to hash this out with them?
Yeah, it's quite difficult, I think, pursuing change in the office to some extent, because the boards don't always meet regularly, and essentially you have to go to 54 different board meetings and caucus a number of board members. We rely a lot on our board administrators, but also most recently, starting in April 1, we've been providing legal support at every meeting for the entirety of the meeting. I have been communicating with all board members on a quarterly basis via letter, because I want everybody to receive the same amount of information, the same type of information at the same time. So I think our thought is we might utilize the survey tool, to be perfectly honest. That might be the fastest way of getting feedback. We do have tools in-house, such as SurveyMonkey, to get that feedback from the boards. Because otherwise, I think it's going to take us forever to move the ball forward, even an inch. And we certainly need to do a lot more in a short period of time in terms of establishing efficiencies.
Thank you. I definitely would encourage doing a poll such as that. I'm sure you're aware that depending on the profession, there may be needs other than what you're looking at. If one profession has a licensing period of 2 years for their license, as opposed to those that have 1 year, obviously that would kind of require a different retention period. If you're retaining them for 7 years, for a 1-year profession, that's 7 rounds. But if it's a 2-year profession, that's only 3. So just wanted to bear in mind that could be a need and it should be explored. So thank you.
Oh, you're welcome. And on that point, Representative, I would just note, from my perspective, we need to retain the licensure file for the entirety that somebody is licensed. And then the question is really how long after the person is no longer licensed do you retain the file? So I think that would be something that the boards would need to consider. Some have, 7 years after a person is deceased. I mean, that's a very long time. But then others are, 10 years after they are no longer licensed. So that's really what we're looking at.
So Ms. Courtney.
Thank you.
Ms. Courtney, for those that are not overly familiar, OPLC is really in its infancy as an organization. So, some of these boards are still going through a little bit of a growing pain, if you will, because they did operate autonomously for a very long time. And, as we all try to find ways in state government to not only make things more efficient, but more cost effective, I can understand how there's still, there's some of these boards are still holding on a little bit to the ways of the past. And, and that's certainly a struggle that you obviously deal with on a daily basis here. So, basically, the first 2 pages of the bill kind of give the broad spectrum and authority that the office needs to have here. And then the rest of this bill, it just really kind of does the minutia of hitting each individual board and what is either repealed or brought in to streamline this. And I've certainly not received any specific objections from specific boards, at least to me as the chair of the subcommittee. And I would imagine that their standard procedure at this point would be to bring them through you. So, if you have any that you're dealing with that you need to bring forward, by all means do so. But the other thing I want to touch on before I go to Representative Schmidt is there was some discussion in the general hearing when it came to the per diem compensation of the boards, and I just want to highlighted this, and I just want to point out that on page 2. Line 6, where section 3 is, the rate of per diem compensation for all boards basically will be set by OPLC, which makes sense to me. What that doesn't say is that it's all going to be the same, and I would presume that you still are going to retain discretion as to what the per diem compensation is for specific boards based on, and I hate to use the word value of time, but certain professions do inherently have a greater value of time. So I would presume that you're still operating that way, that the per diems will be looked at individually.
Yes, absolutely. So right now, I think you're totally correct, Representative, in that the per diem rates shouldn't be the same. What we'd like to do is make sure that every board member is receiving a per diem. Not all boards receive a per diem. The majority of technical boards don't receive anything at all. And so we want to give all board members a per diem, and then obviously look at the amount of time that's required in order to be a board member. One of the things that we're currently doing in the office is a reassessment of our staff. To Representative Schuett's point, a lot of our staff have historically been part-time, which has been a barrier to achieving efficiencies. So you probably noted in the budget that we requested a reduction of our part-time staff and an increase in our full-time staff. But what we're doing right now with the Division of Personnel is essentially doing a reassessment of our staff. And the first step is really classifying the boards based on basically the amount of time that's involved in both administering the boards and being a board member using, quantifiable metrics. So I imagine that we'll use some sort of tool like that to propose different structures for per diems, and then obviously seek the board's input as previously discussed through surveys and whatnot. What we want to avoid is unclear expectations and make sure that we have sufficient amount of appropriations, but also make clear as to when a board member is entitled to a per diem and when they may not be.
So also too, just a reminder that the compensation for the board members comes out of the fees and is not coming from taxpayer money, correct?
Yes, correct.
Very good. Representative Schmidt.
Thank you. Thank you, Mr. Chairman. So let me turn my camera back on. One of the issues we've already spoken about a little bit this morning is the retention of records. And I think while it's nice to be able to go back 10 or 15 years with regard to somebody who may have been a member of a particular profession, a licensed member, one of the problems in doing so is if you have paper records, which is of course what everybody had for a long time, at some point you start to literally kind of suffocate in the sheer quantity of paperwork that you have in boxes or stacked here or there and everywhere. Can you speak to that a little bit more specifically, Ms. Courtney? Because I think that's something that the new members may not quite recognize, that that you are in smaller quarters than you were. I was very familiar with the offices over at Philbrook that you had previously, and I believe you've been reduced to what maybe a third or a quarter of the space you had before, which was not like you were working inside the Los Angeles Coliseum, but you had a lot more space before, and a retention of records is a real problem if you're having to deal with a lot less space.
Thank you, Representative. Yes, we have reduced our space by about 6,000 square feet, which is about a third of what we had previously at Philbrook. Space has become a significant concern for the office. We have begun a push to move all licensing online, and all renewals are now online, thankfully. And so the idea is that if we can at least stop the flow of paper, we can deal with what we have, which is a significant amount of paper. All initial licensing should be online by August of 2022. So that's a goal that we have, and it looks we're moving in that direction pretty nicely. We have started a scanning project where we've been working with the Bureau of Graphic Services to scan in all of our old documentation. And what we're dealing with now is how do we manage that? We don't yet have a document management system that interfaces with our licensing portal. And so that's something that we're going to be looking to hopefully acquire after we obtain a budget. But to your point, yes, we're retaining records essentially indefinitely. And when we moved from Philbrook, we had to clean out that storage shed that was in the back, and we have records dating back to the 30s, the 20s. It's really problematic in terms of just managing paper and being able to retrieve information when we need to.
Right. Just getting at this stuff becomes a real problem when you got stuff that's literally buried at the bottom of a pile.
Yes.
It's kind of like trying to remove the bottom figure on a totem pole.
Yes, it reminded me of cleaning out my, grandparents' house. Not gonna lie.
Speaking as somebody who's probably as old as your grandparents, I know that that phenomenon very well. But one thing that should be referenced in our discussions this morning is the fact that some of the records, especially the Board of Psychology records, where confidentiality is key, and having records that could fall into the wrong hands is a real issue when you're talking about mental health aspects where the client's privacy is essential. Many of the records you're dealing with in other professions are of a completely different nature. And so disposing of them, the physical records anyway, once they are perhaps, as you say, scanned in, is a different matter entirely. So thank you.
Thank you, Representative Allegro.
Yeah, so I wouldn't advocate for retaining paper records forever, but you must have sought some state-owned storage space where you can, move the older files. Ms. Courtney?
Yeah, we do have some storage space off-site through the Department of Admin Services. State space is at a premium. Right now, it's hard to come by. I believe we have records in the Walker Building. We also have a lot of not records, but equipment, furniture that is presently being stored on a truck that we're renting until we can figure out how to basically dispose of that equipment. So we do, and we have looked into securing a storage space, an independent storage space. It's not financially a burden, but it's more of a burden to actually physically maintain all the files in an appropriate format so that they're easily accessible.
So fantastic. So that pretty much covers the opening general part of this. Like I said, the rest of this bill is all just the individual changes to the boards to get them in line. And like I said, I haven't seen any objections, but I'll let Representative Lowly pipe up here and hear what he has to say.
Thank you, Mr. Chair. I noticed there's a lot of repeals in this bill, and I mean that concerns me when you go down line by line looking at some of the things that are being repealed. I think we need to take a closer look and make sure that really need to be repealed. We're not hearing from the boards on them, which concerns me. And I'll start just from the first section of repeals I look at in the bottom of page 5. And I don't know if Ms. Courtney could help me out here. We're repealing under the alcohol and other drug use professionals hearings section, repealing section relative to rules for the conduct of hearings and relative to retaining experts in investigations or hearings. As you know, we had amended the bill that dealt with hearings recently, and we were pretty specific in that the boards will retain the right to the hearings and ask for an investigator if necessary. So I want to know how repealing these affects that.
Thank you, Representative. I just want to look at that. So as just an overall matter, this bill was part of a larger bill that I tried to basically cut in half. And it was drafted when the investigations bill was essentially one that would create one investigations set of rules. And really the gist of that is because it's very difficult to operate under 54, 55 different sets of rules. Specific to LADAC, let me take a look at that. I can tell you why we're repealing mileage is because we'd like to put that in rule. Not all boards have entitlement to mileage, and some boards only have entitlement to mileage. So we think that's better placed in rules so that it can cover all boards. And when you need to change something, you're just changing it once instead of 54 different times. Regarding line 37, relative to retaining experts for investigations or hearings, it's our understanding, working with DOJ, is that the boards no longer have the authority to enter into contracts, that the contracting is done through the Office of Professional Licensure and Certification. So certainly they can still retain experts, but it has to be through the office. So they're not actually going out and making payment because they no longer have their budgets. Specific to number 9, Roman numeral 9, let me just take a look at that because that could be an area. So,
Ms. Courtney, if you have it, please give us the line number and page number.
Yeah, I'm looking at page 5,
Line
Line
36.
36. And Roman numeral 9. Procedures for the conduct of hearings consistent with the requirements of due process. Yeah, so this was drafted when we were hopefully planning to obtain legislation that would permit us to just have one set of hearings rules for all boards. Certainly, if you want to strike that out in light of the recent statutory amendments, that would make sense to me. But that was the basis for those changes.
So that this doesn't affect what we're doing in the other piece of legislation that's going forward.
I don't think it affects it, no. I mean, but this repeal would certainly remove, at least from the Alcohol and Drug Statute Practice Act, the ability for the board to promulgate rules regarding hearings.
Follow up.
Sure.
So the understanding was in the previous piece of legislation that the boards could do the hearings and ask for an investigator if necessary. Taking out this about making rules for hearings eliminates that from them, correct? And we didn't want to do that. Is that correct?
Yeah, that's correct. So in light of the amendment that the committee approved, you may want to change that so that we're not repealing page 5, line 36. I mean, again, our perspective is that it's incredibly difficult to have so many sets of rules that are procedural in nature. And that's really the gist of hearings rules. Is the rules are centered on when you file a motion, when you file a pleading, how long you have to respond. They're not substantive in nature. And so from our perspective, there really is no reason why you would need to have 56 different sets of rules, but certainly to in line with the committee's recommendations regarding that amendment, you may want to eliminate that repeal.
Thank you, Mr. Chairman. Could you make note that we may want to
I did.
make that line?
And, on top of that, Ms. Courtney, so if that's the case under the alcohol and other drug professionals, do we find this exact repeal anywhere else? I mean, you know what I mean? Because we're looking at, we just touched on one group, actually, the second group in here. Does this occur in other parts?
Most likely, I see it in 317A, which is cosmetology on page 11. I see it on page 11, line 36 regarding 326H, I think is dietitians. So, I mean, what I could do, Representative, is I could go through and propose an amendment that would eliminate the repeals regarding hearings. If that would be helpful to you.
Sure, because we're going to need someone to do a deep dive here into where that's located.
Yep.
In all the various boards, because again, if we're establishing this to streamline and be consistent, then any amendment brought forward would have to be streamlined and consistent.
Yes.
Mr. Chair, if I may.
Yes, Representative Stewart.
Suggest, I'm thinking in terms of engaging investigators, and I'm wondering if back on page 1, if the line that says the office may contract for the services of investigators, hearing officers, legal counsel, and experts as necessary, if we inserted before the words as necessary, perhaps in consultation with the appropriate board. Would that be acceptable to Ms. Courtney? I assume that you would be doing that anyway, but I think perhaps members of our committee might be more comfortable with that wording included.
Yeah, I would have no problem with that.
Thank you.
Just make a note.
Now, Representative Stewart, you said various boards, maybe appropriate?
In consultation with the appropriate board. In other words, if they're engaging an investigator for cosmetology applicants, they would consult with that board, obviously, to be sure that the investigator that they are considering is something that that board is comfortable with.
Ms. Courtney, in your experience, and I know you've been with OPLC for a brief time here, would the request for an investigation typically come from a board, or would it come from the OPLC office itself?
That's something that we're still trying to work through. Historically, the boards have basically started investigations. I can tell you from my perspective, I have concerns with that idea because, and I've shared this and we've talked about it openly with the boards and legal counsel, because one of the issues that we're running into is whether or not there are perceived violations of due process, or actual violations of due process. When boards are intimately involved in the actual investigative process, it's very hard for them to at least remain or create the perception that they are a neutral body that is also the adjudicating body. So when you think of boards, the boards are the judge. So should the board also be the police officer and the prosecutor? No, but that's essentially the statutory authority and the framework that's been created for them. And so what we've tried to do, working with collaboratively with the boards, is try to like silo that process, either to have a board member who's kind of like reviewing complaints and making recommendations and or assisting with the ROIs and just bringing the reports of investigation to the board for decision making. But there are a number of boards that still insist on being intimately involved with the investigations process, which is concerning.
I can understand that you're in the old line of, you know, who's guarding the guards here.
Right.
It becomes circular in a way.
Right.
So I definitely see your point with that.
On the other hand, some professions are so detailed that only someone who has done that work may know the ins and outs of how you should proceed.
Certainly agree, Representative, which is why I think we're trying to set up a framework where we pair experts, we retain them as necessary, or we recuse board members to utilize their expertise, while at the same time preserving the neutrality of the board that's actually going to be voting.
Representative Schmidt.
Thank you, Mr. Chairman. Some of us will recall that's one of the problems that we've had with the oversight of daycare centers, that some of the licensees have brought up real problems with the idea that the agency is judge, jury, and executioner. And so that is, as Representative Schuett was just pointing out, it's difficult when you have something that's very detailed that only professionals would easily understand and have any background in. By the same token, the judge, jury, and executioner thing just lends itself to potential abuses and authoritarianism on the part of some practitioners of some oversight agencies, but maybe not having that particular issue in statute in this bill at this time until the OPLC has worked out some kind of a balancing act where you have neither of the extremes included. I think that's something that I think that's where we're headed, and not trying to put that in statute at this point where we haven't quite worked out how we're going to do it.
Thank you, Representative Schmidt. Representative Allegro.
Yeah, I agree with that, and I actually would even expand upon it. I think it's a critical issue because not only can a board be, or any agency really, be a judge, jury, and executioner, but they set the rules, they're the plaintiffs, they're the investigator, and then they're the judge, jury, and executioner as well. So I think this is an important point.
And also too, as we saw last term, there was a significant amount of concern brought forward in the world of child daycares, and that I don't think is super unique to that one particular group. So I do agree that having that a bit of separation there for the sake of due process really does matter. And also too, we're talking about investigations of, when you get to the point of bringing in investigators, we've had a substantial violation here, a substantial problem. And that should be, if we're at the point of investigators, should be obvious to someone that is more than just a technical expert. If you're looking at an egregious act that a board would say, we need to take action and investigate this, you should be able to convince me of that. And not just a subject matter expert. This isn't a matter of, did I use a 90-degree elbow in a plumbing fitting instead of a 45? You wouldn't elevate that to that sort of level. So these are acts that should, when brought forward, should make sense to lay people to a point. So
well, that's why having Mr. Porter as part of the process, where he has experience in investigations and administration from that end of things, because there is going to be some uniformity in investigations above and beyond the highly technical things that you might have in some professions. So it's a balancing act, and it's very difficult. That's why I'm suggesting, and I think we're heading in the direction of excluding that from this bill, so that we're not jumping off the diving board before we're sure whether there's any water in the pool.
Representative Golden.
Thank you, Mr. Chairman. And I just want to remind the committee that there was in Senate Bill 133, Section 7 was the authority of the Office of Professional Licensure and Certification for administration of rulemaking and enforcement of investigations, hearings, and appeals. The subcommittee did a thorough vetting of that bill, and working with Tom Broderick, Ms. Courtney, and all those parties, amended the bill and came back with a final product that I think we were happy with. So as we continue to talk about investigations, hearings, and appeals, that was already part of Senate Bill 133.
Yeah, and I think that's certainly your justification for removing that part out of this bill. We don't want to, if that's already been worked out, we don't want to certainly don't want to cause confusion in the statute here.
Correct.
So no, I certainly have no issue with that. Again, if it's been addressed in another bill, there's no point in doing it here. So, but I think we've certainly covered that aspect of it. Do either of you have objections to that?
Right. Just confirming Representative Goldie's remarks. I'm recalling that specific aspect. So that is something that we were happy with this solution we'd worked out.
Representative Jewett?
Is Mr. Broderick on this call? I don't see him.
No, he's not on. He's on another. We're trying to provide legal support to all the boards right now, and so
I know, spread a little bit.
back teaming a little bit. I just got off a land surveyor, so
I'm just mindful of what Representative Goldie just said. I would hope that you and he would take a good look at this bill to see if there are conflicts such as that we can wipe from this bill, so that we're only concentrating on one.
yeah, absolutely. That's what we'll do. We'll go through the bill and we'll make sure it's consistent with the amendment that was put forth by the committee regarding 133.
Right.
I do. If we could get some clarity on page 1, line 7, the office may contract for the services of investigators, hearing officers, legal counsel, and experts as necessary. I assume that we still want to keep that in, but just make that modification to be in consultation with the boards.
Yes.
I'm fine with that. Yeah.
And that
Right.
seems okay to me.
And Mr. Chair,
Yes, Representative Gold.
I also have, as we go down looking at the things that are being repealed, a few questions on some of these issues as we go further down the bill. If I may ask some questions on those later on.
Yeah, what do you got?
On page 8, line 8, under Allied Health, relative to rulemaking by the Allied Health Board of Directors. Why are they not, I'm not sure what's going on there and why that's being repealed. Why are they no longer allowed to participate in the rulemaking?
Sorry.
Thank you. We're not removing all rulemaking capabilities. Let me just cross-reference it. 13. It would just be rules regarding fees, rules regarding the design. Hold on. The design and content of application forms. I think we subsequently make clear that the boards retain the authority over eligibility requirements. Procedures, forms and fees for temporary licensure, and procedures for receipt of misconduct complaints. So this would be one of those that as we go through, we would probably modify to not repeal 328 F13 Roman numeral 2 regarding the receipt of misconduct of complaints.
So start with 3 to 5 instead of 2 to 5?
Yes, exactly.
If I may, Mr. Chair, I think Ms. Courtney had said that she's going to go through and re-examine all of the repeals with reference to those specific areas. And it's appearing that we're going to need another meeting on this bill to deal with those, to be able to put forward a cohesive amendment.
Right, and not having Tom Broderick involved in this process today is, I understand he can't be in two places at one time, but since he is certainly the mechanic, if you will, that is doing the work on this, it's imperative to have his involvement in it. So I agree that we're going to probably need a second session.
Yeah, absolutely. Tom, we can get Tom involved. Absolutely. I was the one who drafted this bill and I drafted 133. So I've drafted them all pretty much. So I'm more than happy to also participate, but we can certainly get Tom's involvement as well.
Right.
Please understand.
Well, it's good that in a sense that you've been involved in the drafting. It means you do understand what's been done. By the same token, as executive director, your time is precious with regard to being the director and not a mechanic as well.
Thank you, Representative.
So we are going to have to be mindful of some deadlines here with this, because we are approaching this month.
While we're thinking about this, maybe I can mention just one other aspect which hasn't been discussed this morning. Back in the early days of Representative McGuire's time in the House and on this committee, there were a lot of repeals that were in one of the bills, and it was pointed out by some of the agencies that some of the requirements that were being repealed, or some of the statutes that were being repealed, were the underpinning for some of the structures that had been created, and by repealing them, you were kind of tearing the basement out of the building, and so those repeals were withdrawn because they would have wrecked the legitimacy and the structure of the agency. So that probably is not the case here too much, but we need to be mindful of that as well.
As you have invoked the name of our chair, Representative McGuire, if you may respond. Representative McGuire.
Thank you, Mr. Chair. I'm glad to hear that you're looking at this in such detail and coordinating it with 133. I'd also like to remind you to take a look at the amendment that Courtney presented to me, and I believe, and I did send it to the committee yesterday, I think. And the deadline for this bill is 27th.
Yes, the 27th. So that's the deadline to get it out of the full committee.
The full committee with a finished amendment, yes.
Yes.
So other work session sounds like it's going to be necessary.
Yeah, I agree.
So our major concern is basically fitting another subcommittee in to accommodate staff that needs to facilitate a remote meeting such as this.
Yes, I scheduled next week, Tuesday and Thursday, and the following Tuesday. You can, I believe that there are plenty of openings that week of the 8th, well, Monday would be the 17th. So
Yeah.
you can schedule what day is convenient for the subcommittee.
Okay. Yeah, I'm showing we already booked for the 18th.
Yes.
Right? That's a full committee.
We have an executive session that day for as many of our bills as we
That's right.
can. If you have a short committee meeting earlier, or you can, start at 2 o'clock or something like that. I'll have another final exec session. Or you can get another day. It doesn't seem there's much competition for licenses.
Okay. Yeah.
And a reminder, this is subcommittee, so you only need a 24-hour notice.
Right. You can go for a Monday. Mondays are really available.
Yeah.
Mr. Chair,
It would be good just to avoid the 24-hour notice if at all possible. If you can get it in the calendar, it's definitely a preferred way to go.
Yeah, we would, Pam, at the earliest, this would be the week of the 16th. So.
Okay, great.
Mr. Chair, Representative McGuire's audio was breaking to me. Did I understand her to say that she had forwarded an amendment on this bill to the committee members?
I believe she did, and I am.
Can we have that? Was there a numbered amendment, or what date should we look for that on?
I found an amendment from Senator Carson, 1153S to Senate Bill 58. Is that the one you're referring to, Representative McGuire?
No, although that one needs to be considered as well. This
Okay.
one, I sent it to, I received it from Ms. Courtney as she wanted to put it into 1.3, but I thought it was more applicable to Senate Bill 58, so I sent it out to the committee for that. I will step away. When I'm finished talking to you, I'll go find it and send it to you.
Thank you.
It was sent to eliminate the requirement that board members physically sign a license. It is a nuisance, and I can't see that it adds value to the. Okay.
Yeah.
I think I do recall seeing that amendment.
was talking about it. I just can't find it.
I will forward it to you. I think I can find it fairly quickly. So
Thank
only
you.
one person. No, sir.
Okay, we're not under a time crunch right now, so. Yeah, and Pam, did you get a copy of that?
I remember seeing it. I'm not finding it right now, and I'm looking for it. I've got the Carson amendment to Senate Bill 58 that I just made copies of, and I can bring down to you. And I just sent it to everybody, but the other amendment I'm not finding.
It seems like I remember seeing something about signing, but I'm not finding it either.
Yeah, Pam,
I think I saw it as an unofficial
Mm-hmm.
amendment.
if
That's what it is. It's a draft OPLC amendment. That's what I have.
Yeah, if you could bring those down, that would be great.
I will do that in a few minutes, sure.
Now, as far as the removing of the physical signature part of this, it is in fact 2021, and the ability to handle things digitally certainly exists, and that's I can see the problems with this outdated requirement. Really, it's not. Times are such that all you're really doing with these signatures is just affirming that things are in fact valid, and that honestly the OPLC would be doing that anyway if things were called into question. So I don't see any reason why this is would be difficult at all. I do see one representative require for Senate Bill 133, Section 12 that you sent to us on May 5th. But that does not have 15.
Excuse me, Mr. Chair, was that a question?
That was just kind of a statement as to one of the emails that we did receive.
So you have the two amendments, one official from Senator Carson and one unofficial from Ms. Courtney and myself.
I don't.
I just resent it to the committee.
Okay. Is that on our legislative email? That route?
Beg pardon?
I just got what you sent, Carol.
Good. In that case, I'm going to step out and let you guys.
So it should be out there for anybody who's looking.
Yes, I have my copy.
Okay. F18. Oh. I didn't get that. I didn't get an email from you, Carol, at all. Matt did. Yeah, but we have a physical. It looks like we have a physical. So. Yep.
We'll see what happens next.
Oh, I don't know. That's odd that I didn't get it. Should be on that list. I guess I'm not on that. I'm not on that email list for some reason. All right. Well, we can. If Representative Schuett and Representative Schmidt have that, we can certainly take up Senator Carson's amendment.
Apologize, Mr. Chair. Someone was at my door.
Were they delivering an amendment to you?
No, they weren't.
Okay. So wonderfully, the amendment from Senator Carson says, okay, so to insert section 1 of the bill. So we're looking at 310-2A, which I believe is line 11 and on page 1. It's 310-1AD, section 2H2. So this would be after line 29, the bottom of the
So,
page.
right, the top of page 2.
Yeah, in essence, it would become the top of page 2. So such, let's see, what's the change here? That's the same. Okay, so what has changed in this amendment is the bottom part of the italicized where it says rules for pharmacists and pharmacy technicians licensed by the pharmacy board shall include requirements for training and experience regarding pharmacy laws and rules relative to the practice of pharmacy. That is extraordinarily specific to include in a general section. Unfortunately, Senator Carson's not here with us to give us context. Ms. Courtney, do you understand the context of this?
Yes.
Okay, help us out here.
Thank you, Mr. Chair. So this came about essentially at the request of Representative Merchant, who had expressed concerns regarding the original bill as drafted that was presented in the Senate. The concern was basically that we have 3 investigators here who are employed by OPLC who assist the Board of Pharmacy. And a number of states have moved in the direction of utilizing non-pharmacists or non-pharmacy technicians to conduct inspections for pharmacy, which both the pharmacy board, myself, and Representative Merchant agree is not conducive to protecting public safety. And so Representative Merchant and the board wanted to make clear that, you know, in the event I leave and somebody else is responsible for hiring, that the statute mandated that that the inspectors for pharmacy actually have the requisite experience in pharmacy, as opposed to law enforcement officers as other states have used.
Okay, I can understand that, but what then? Why would this be put into the general part of this and not under the statute where under one? You know, this would be page 26 under pharmacy board.
So I apologize because I don't have the actual amendment in front of me. The one that I'm looking at says amend section 104 of the bill by replacing page 25 lines 30 through 34 with the following: pharmacy board inspections shall be provided by pharmacists or pharmacy technicians licensed by the New Hampshire Board of Pharmacy who have training and experience regarding pharmacy statutes and rules.
Yeah, that's the second half of this amendment.
Okay.
What I read was the first half of this amendment that is inserting this into, rather than inserting it into the pharmacy board part of it, it inserts it into basically under administration of the office.
Yeah, I think the only justification I can offer is that there's a general disconnect. The staff are employed by the office. I think that that's still something that boards have a concern with, that they don't have direct reports, they don't have direct staff. And this has come up in the context of pharmacy because technically the pharmacists who are conducting inspections don't work for the pharmacy board. And they can be conducting inspections and do conduct inspections in other professions like veterinary medicine and whatnot. So by virtue of that, because they're actually staff and not specific to pharmacy, I think it could go in the general administration, just to make it super clear that these types of staff should have this requisite information, training, education, experience. We could certainly limit it to 318(9)A regarding inspectional services, but I can envision a scenario where we're using a pharmacist staff member to do something that's not, not specific to 318.
I mean, you have to live with this, so that's why I'm asking.
Yeah, and honestly, this was just a compromise. I mean, we didn't draft it with this language because we didn't think it was necessary because I completely agree that, and by virtue of the supplemental job descriptions, we're not allowed to hire law enforcement officers or anybody that doesn't have the requisite experience. But this was essentially a compromise because, just to make sure that the pharmacy board was comfortable with this language. So if this is what they were comfortable with, and I'm happy to, I think it's fine. I don't think it's necessary, but I think it's fine.
Can I just interject? And just so you know, Ms. Courtney, I just emailed you the amendment.
Thank
So,
you.
so you can see it in real life. And I'm listening to the discussion, but looking at the amendment, that the sentence added to the first section on lines 7 through 9 of the amendment, and it doesn't refer to inspections. It just refers to technicians that are licensed. So it seems kind of disconnected from the second one.
Yeah, I agree. It should probably be changed to reflect that it's staff who conduct inspections.
Yeah, I think that would help everybody.
Yeah, this is right. As I read this, that's why I asked if it was appropriate to be in this section, because it doesn't seem like it has anything to do with inspections. It talks about pharmacy tax.
Yeah, I can certainly make that proposed change and get that back to the committee.
Okay, we'll add that to your laundry list of here. So looking at the bottom half, and the amendment, I'll give you a chance to bring that up. This does refer to section 104, which in fact in the bill is relative to pharmacy boards. So again, this is also adding a sentence at the bottom. That's the change. The first part of italicized is already there. So the addition here is similar to above, where it is the last sentence. Pharmacy board inspections shall be provided by pharmacists or pharmacy technicians licensed by the New Hampshire Pharmacy Board. Okay, so is this just not repeating? Are we looking at redundancy here? So it sounds to me like the first part of this doesn't need to exist.
I would agree with that.
I mean, because in essence, if you're changing the first section of this to what we just talked about, you're just creating language that it's already at the bottom.
Yeah, I agree. I don't think it needs to be there.
So we can just do away with the top half of this.
Yeah.
Event. Okay.
Yep.
That makes a whole lot more sense to me. Does anybody have any questions on the Carson Amendment? Okay, fantastic. So moving on now to the other amendment, which is now this
Is that what Ms. Marling just resent to us also,
it is.
OPLC
Now,
amendment?
Mike, Representative McGuire, if you're still there, this says amendment to Senate Bill 133. So is it fair to presume that this is not applicable to Senate Bill 58? We may have lost Carol.
That's what I'm seeing also, and that was my concern, that we're into issues that are contained in 133 also. And I think we need to be careful that we're not
We've
overlapping.
Well, exactly, and Representative Goley's already brought that up, that we can't bring two bills forward that in essence are covering the same area.
Right.
That's
Yeah.
going to become problematic. So I guess if once we get Representative McGuire back, we can find out if this is, because that's what it literally says amendment to Senate Bill 133 on it. So.
Right.
Yeah.
Yeah, I thought she had said that it was drafted as an amendment to Senate Bill 133, but she felt it was more appropriate to Senate Bill 58. but I could certainly be wrong.
Okay, so then while we're waiting on that, looking through this, the first page, it's signed and dated by the chairperson, and then we have signed by members, signed by members, signed by members. This is hand sealed, signed by members. Okay. So what this is doing, I mean, since we have the time, and regardless of whether it's 58 or 133, we're all gonna be looking at it anyway. This seems to be consistently across the board, removing the requirement of physical signature. I don't see anything else being struck out. That's consistently struck out across.
I agree. Mr. Chair, if I can point out, Representative McGuire lives fairly close to me. It is extremely windy here. I
Yes.
assume it is where she is also. So she may be having electrical issues.
Oh, yeah, clearly she was having internet issues when she addressed us earlier. But I mean, this is
I
Mr. Chair,
agree.
yes.
These are all,
President Gully.
I'm just following this email chain from that Representative McGuire had sent out attached to this email. And I don't know if Ms. Courtney wants to talk to us about this. This originally came from her to Representative McGuire and Representative Sitek, and then was forwarded to Pam and you, it looks like, wondering if it was germane to 58 versus 133. So I don't know if we want to hear from either PM or Ms. Courtney on them, who are also associated with this email attachment.
I'm happy to speak to it. This is an issue that has come up recently by virtue of the fact that we were trying to move to an electronic platform, and it's very difficult for us to physically keep capturing board members' electronic signatures. I'm not even sure if that's appropriate or consistent with the statutory requirements that exist, as you see in front of you. So I had reached out to Representative McGuire regarding this amendment. This is completely, certificates, I believe, are separate from what's in 133 and 58. So I had reached out regarding 133. From my perspective, I think it could go in 58. I think it can go in 133. But it's a solely separate issue regarding certificates only.
Mr. Chair,
Yes, go ahead.
I guess my question would be either to you or to Pam, is this considered germane to this bill or non-germane? And would it need a hearing?
Yeah, I think, what my sense of it was, since 58 is relative to the administration of the OPLC, and this is clearly, to me, it's an administrative feature that it is germane. I mean, I'm not the only one who can weigh in on germaneness, but for my sense, it fit in with 58.
And
Okay, thank you.
That may be why Representative McGuire stated what she did in reference to this being more appropriate to 58. Because this clearly is just an administrative change. That's all this. It's just striking out the requirement for, and again, too, we're talking about streamlining and consistency here. If we're going to go to electronic records, we need to go to electronic signatures. I mean, it would seem weird to me that we would maintain databases of electronic records and then have to have a random piece of paper with physical signatures on it. That doesn't seem to jive with the intent here of what we're trying to
I
do.
very much agree with that position, Mr. Chairman.
Thank you, Representative.
Mr. Chair, I have one more question to Ms. Courtney, if I may.
Absolutely.
In the email, the initial email that went out with this amendment, you mentioned Senate Bill 13 that this language was part of and didn't move forward. Could you give us a little more insight as to what that was?
Yeah, 13, it's a Senate bill that pertains primarily only to fees. So to be honest with you, I'm not sure why when I was drafting this, I included it in 13 when I went back, and I'm like, oh, well, probably shouldn't have done that. 13 basically was the portion of 576 that removed the provisions from the Practice Acts that granted the boards the authority to promulgate fees and or created statutory fees. Because if you recall, 310A theoretically grants to the office the ability to promulgate fees, but the boards have retained that authority in their Practice Acts. So that's that cleanup portion, and it went to Senate Ways and Means, and it's just kind of hung out there. I don't know if they're going to try to tack it on to HB2 or if they're just going to, lay it on the table. I don't know what they're going to do with it.
So,
All right, thank you.
If I'm hearing you correctly, this amendment here that removes the electronic signature part was sent to Ways and Means? Yeah,
because it was tied up within the fee bill. I don't know why I drafted it, Mr. Chair, in that way. I have to say it was very difficult, I think, to split the bill. And so it was such a drafter's error, to be honest with you. It was tied up in a fees bill, so that's why I went to Ways and Means.
Okay. I was unaware that the fee structure of OPLC would ever go to Ways and Means. That just seems peculiar to me, since ED&A has the responsibility of completely dealing with OPLC. But that's this year. So,
Mr. Chair,
yes,
if we are going to incorporate this draft amendment into Senate Bill 58, I think rather than, I haven't gone through to see if all the language for, well, I'll just pick one, the one that I'm looking at, section 329:14, action on license applications. It's page 2 of the draft amendment. Rather than incorporate all of this language to just show that we're striking that one line, if we could incorporate these pieces under those headings and just show the line that's being deleted, I think that would simplify things. And one thing that I would point out in this specific section, this is probably for Ms. Courtney especially, Roman numeral 4, licenses shall be stating that the license, the way it's lined out, it doesn't make sense in that specific sentence. I think it needs to say stating.
there's a grammatical problem.
Yeah.
I think it says licenses shall state that the licensee is authorized.
Okay.
It's a little bit funky the way
Yeah.
the ing was struck out, but
Yeah.
it's a little hard to read, but I think it works.
Okay.
Yeah, your strikeout kind of, at least in my copy, kind of found its way over to the E. So
Yeah, I'm just saying if all of the, the huge paragraphs are included here to show the line struck out, to show the context, but if we don't have that entire paragraph in this bill, I'm just saying perhaps we don't need to incorporate all these paragraphs, because that's going to make this bill even larger.
Yeah, I think OLS would just do the paragraphs. They would just break out. But I think Ms. Courtney, just wanted to give you the full context.
Yeah.
Most of this is just the paragraph, with the exception of maybe the second to last one and the one that Representative Stewart just.
I haven't found all of them yet.
Some of them it is just the paragraph. So, and we would need the paragraph, right?
Yeah. Yeah. For example, on like the first one, 328F, I think if it just included Roman numeral 4, and then obviously if you're striking A, B would just be renumbered to become A, but yeah.
Great. Yeah, as long as OLS is happy with that.
Yeah, I think that's all that would need to be put forward as the amendment to this bill. I think. Like I said, I'm still looking through trying to find all the sections.
I would imagine too with on the third page section, the 151 part where part 3 is struck out, that 4 would become 3,
Yeah,
and then that would also, I mean, there is pieces of statute where there are Roman numeral lines and they just say repealed on them. I mean, that does exist. So,
right.
you know,
That's what I'm saying. I don't know that we need to have all this other language.
the rest of it all just seems to be parts of sentences. So
Yeah,
in those 2 particular locations, I'm sure that's fine. We'll let OLS wrestle with the alphabet. But is there any objections to what we're doing here with this? It seems pretty straightforward to me. Again, the focus of this is consistency, and
the only
Oh, no, we're doing a lot of good stuff here.
so beyond that,
other suggestion I would have,
Yeah.
I have gone through the bill previously and noticed in several places, and I don't know that I've caught all of them, but I'm trying to find some of my little quick notes. That's records. For example, page 10, down under repeals chiropractic.
get a line number for me, Dave?
40, line 21 through 24.
Page name?
I'm sorry, wrong line. Lines 29 and 30.
Okay.
A true record of all their official acts shall be made and preserved. And it did say by the board's executive director, and that's changed to Office of Professional Licensure, so on and so forth.
That exists in dozens of locations throughout this document.
Right, exactly. That's my point. And I'm just saying retention policy established by the office. And I'm wondering if we should include that language that we discussed in the very first page about in consultation with the appropriate board.
The only problem is that at this point with this, what happens if you have 3 boards that don't like it? Or 3 boards that want to retain this for some reason? We're either going to have to dive into this pool or we're not.
Well, my point is that some boards may feel the need to retain things longer. Ms. Courtney did say that there could be possibly 2 or 3 different retention periods agreed to. And I would hope that in her polling of the boards that she would be able to align those accordingly so that you would end up with only possibly 2 or 3 different retention periods. So that I just bring it up because, like I said, I did go through the bill before we started a few days ago, actually, and noted a few of those places.
In this case, in order for that to work, the OPLC would have to do this. Statutorily, I don't think that we need to handcuff that. I think that Ms. Courtney's office should be just handling that through the authority we give them.
All right, like I said, I just put that forward because the thought had occurred to me when I was originally going through the bill.
Is there any other parts of Senate Bill 58 that are in need of discussion beyond the marching orders we've given to Ms. Courtney and the changes that we've outlined in the 2 amendments? We have no attendees with hands up, and we we're under the cone of silence with the rest of us. So if that's the case, then I will close the subcommittee hearing on Senate Bill 58, and we will resume at 1 o'clock for Senate Bill 104 with, and just for those of you at home, Senate Bill 104 does have two amendments, one from Senator Carson and one from Representative McGuire, that we'll be addressing along with.
Mr. Chairman, if I might, I received a call from Senator Reagan a while back, maybe somebody else did as well. I believe he is going to be unavailable for this afternoon, and he asked me to speak up for the
Wow,
We've
Lost the audio.
you lost your audio, Peter.
oh, I don't know what that's all about.
Weird.
It's on at my end. Are you hearing me now?
We are, yep. Yeah, it's
Okay,
like
so
we're watching.
So Senator Reagan is going to be unavailable this afternoon as he expects. And he's asked me to speak to the subcommittee with regard to the JC represents. And Representative Roy is he with us this morning?
Was,
Representative Roy is currently on the JCEC with me, and Representative Sitek was on previously to Representative Roy. So
sure,
they're members of the committee who are knowledgeable.
okay, yeah, we'll be happy to go through this at 1 o'clock.
Great. Just to alert the committee that Senator Reagan will not be there.
That's okay.
Thank you.
It must be very windy in Dover, because watching you is kind of like watching a foreign movie in subtitles, because your lips are not matching what you're saying. So
Well,
with that, Pam, if you want to throw the notice up that we
Chair,
yes,
excuse me, I have amendment 1202 for 104. Do you have, is there a number for the second amendment?
Yep, it's 1195.
Thank you very much.
You're welcome.
All right, I'll mute the room, and you just need to remember to unmute when 1 o'clock comes around.
Fantastic, thank you.
You bet.
Microsoft Word here. But
All right, so I've unmuted us now.
Thank you. Get 2 minutes. Get that amendment. Oh, it took forever. Show up.
your app was professional.
Yeah, I tried to, or just my internet's not.
Because I got it right away.
Yeah.
And just use. Understood.
It is 1 o'clock, so we are going to get underway with Senate Bill 104. We'll open the subcommittee meeting. As a refresher, Senate Bill 104 is adopting omnibus legislation relative to the classification of state employee positions and reverse auctions. I don't believe we're going to be auctioning off state employees here, but these are together in this omnibus. The first part of this bill is relative to classifications within state employee positions. This is deleting 6 positions, all within the Department of Health and Human Services. And it's establishing 8 positions, most of which are in Health and Human Services.
And Mr. Chairman, if I might just interject,
Sure.
Commissioner Arlinghouse is here, and he certainly works closely with the Joint Committee on Employee Classifications. Just so you're aware, he's there in the audience. I don't know if you want to. He hasn't raised his hand or anything, but
He would be my leadoff hitter on this one.
okay. Now his hand is up here. I'll bring him over.
All right. Commissioner. The floor is yours.
Am I unmuted now?
You are.
Oh, there we go. I'm sorry. I'm here with Tom Kerr, who's one of our lawyers, who knows more about the reverse auction than I do. And then I'm likely to know more about the other bill than he does. Not that he didn't have a hand in both of them, but I'm happy to help you with anything or talk about anything or answer anything.
Well, we're starting with the first part, which is the salary classifications.
Okay. So I think I had said to your team that on certainly on the the primary piece of it is just the regular JCEC cleanup bill, if you will, what they do to memorialize the decisions they made, which happens every year. And then our part is about making a handful of our senior leadership positions that aren't unclassified, and then standardizing how they're treated based on who they are, and directors and above have a term, governor and council.
Sure.
Director level is that. So I think it's fairly straightforward. And that's the amendment that you haven't adopted yet.
Yeah, Representative Leggery has a question.
Hi, thank you. For a layman, would you just give I don't know, 2, maybe 3 sentences, just to, lay out for me why the changes are and what are the key advantages? Just simple terms.
Sure. So in the state system, most employees are classified. This is the executive branch. The legislative branch has its own pay schedules, and the judicial branch does its own thing too. But in the executive branch, the lion's share of employees are classified employees, dating to the implementation of the merit system in 1940, based on Social Security Act amendments. What it means functionally is that they are all hourly employees who are placed into one of 35 levels on a grid that has 9 steps, but has 35 labor grades. The positions are evaluated and placed on that. Over the history of the state, senior positions, originally called officers of the state, and at the time, the treasurer and the comptroller and the major department heads, and it became a slightly broader group over time, are salaried employees in an unclassified grid. It's also a grid where most employees are on a labor grade. They're lettered instead of numbered. AA is the lowest, and I believe that the governor and the commissioner of health and human services are both MM, which is there are higher grades, but there's almost nobody at them, except I think the medical examiner. But people are placed on that grid. Commissioners across the state are all on that level, assistant commissioners and deputy commissioners, and most directors, many directors. In state, it's sort of hit and miss. In our department, some directors are, some directors aren't classified or unclassified. Think of classified as hourly, unclassified as salaried. Those are the major distinctions between the two. Many of our senior leadership positions are, but not all of them are. The advantage is to make a consistent group from our department standpoint. So every director is, not almost every director. We have some deputy directors who are, some deputy directors who aren't. This would be all deputy directors, and then a handful of similar positions in terms of the level of responsibility that they have, such that they are senior management. The additional ones are, we have a position called Senior Operational Analyst. That position is unclassified, but we would make clear that it would be like all other classified below division, which is that they serve pleasure of the commissioner as opposed to for a term, which means not so much that, it doesn't mean so much that they live and die on my whim. It means that they don't have a term that ends, where their job ends and they must be reappointed. They just have a job. It would also be true of the internal auditor, a position that's currently vacant. The plant and properties superintendents or bureau chiefs, the people who are responsible for positions that at one time were the superintendent of building and grounds back in the day. Those 3 major positions. These are all positions that are at the very highest levels of the classified salary grid, that realistically function as if they were salaried employees, but don't actually function that way because they're hourly. They do an hourly time card, and you have to be careful about, calling them after hours, or hey, it's 4:30, we can't still be meeting, and things like that. So they would become like all other senior leadership positions.
Thank you, that helps.
So Commissioner, also in part 1, after we go through just the boilerplate stuff to codify JCPC, there is a change being placed here on the chairmanship of that actual committee to to go from a rotation of an annual chairmanship to every 2 years.
So that's, I think I can speak to that, but I'm not sure for sure. It's not actually our amendment. That's a decision that the committee itself made. And I think what's happened historically is that they've done a House member 1 year, a Senate member 1 year to alternate. And I think what they decided, maybe Representative Schmidt will know more, but I think what they decided is that operationally, that's too much. It changes too often. And so they still want to switch back and forth between the House and Senate, but want to have it switch back and forth on the biennium instead of on the annum, as it were. And I think it's for simplicity's sake and because so many things cross an annual line. You know, you might have a meeting in December and then the follow-up meeting is in January or February. And it's a year. Whereas typically, if you use the election year as the barometer, things don't actually cross over on that. And so I think it's simply operational efficiency, so that instead of it being Representative Schmidt 1 year and Senator Reagan the next, it would be Representative Schmidt 1 biennium or whoever, and Senator Reagan the next. And I think it's just for operational purpose.
So as far as part 1 goes of this, do we have any concerns or questions on part 1? Representative Schuett?
Thank you, Mr. Chair. Good afternoon, Commissioner. I'm curious, you mentioned that with the hourly employees that say you're in a meeting and it's going beyond 4:30, there's time to quit work. What happens if they should stay beyond that?
Well, under the current scheme, there are significant there's a significant body of regulation that the federal government has under FLSA, I think that's Fair Labor Standards Act, and there are a whole bunch of rules and regulations. Some of them deal with the distinctions between exempt and non-exempt, which in most private businesses in most states, frankly, are typically, not exclusively, but typically based on salary level, where people are treated somewhat differently. You know, certain employees, and you can understand this, think of it like our grounds crew. They are hourly employees. They're meant to be hourly employees, and there are very strict rules and regulations, whereas managerial positions are treated differently. Because of the way our system works, you must work a 37.5-hour week. You must keep a time card that is accurate for a 37.5-hour week. If you work a 38th or 39th hour, you must be paid an additional X per hour for that. The statutes, or I'm sorry, the budget tends to not allow for overtime. There's some positions that it does and you budget for them, but not for that. So there are very strict sort of rules and regulations on, you know, what time did you get here? Did you get here at 8:10 or at 8:12? Did you leave at 4:30 or 4:36? If I send you a text at home at night, you know, I'm obviously doing a lot of work at night. And if I send you a text or an email at home, you should not open it until first thing in the morning. And, you know, there are a lot of employees who just don't worry about it and do it anyway. Well, technically, you're in violation, right? Where you know, they're not meant to come in on a Saturday, because if you come in on a Saturday, I have to pay you, and I'm not budgeted for that, so you must stay home. Early in my tenure here, there was an employee who was disciplined for working too much. And it felt really weird, right? Like we were giving someone a hard time for working too much. And it was because they had no budget for overtime. And she said, I don't care, I'm gonna put in for it. And her manager said, I can't let you decide to ignore that. And she said, this is ridiculous. You know, I'm making $90,000 a year, whatever she made. It was something like that. And it's, you know, I'm working a 38th hour. I'm not doing 75 hours a week. I'm just working an extra half hour to catch up on stuff. It's like, I'm sorry, you're not a salaried employee. You're an hourly employee, and we have to treat you as such. And And I'm not critical of that because those restrictions are in place to protect employees from abuse from supervisors but in the most senior positions in state government, it's more than reasonable to expect people to be salaried. And they expect it too, frankly. If you start from the outside, you just think it's weird. And so we're taking only our most senior positions because, beyond that, there are all kinds of other considerations you would have to get into, but only our most senior